Hi again. As promised, in this video, I'm going to provide a bit more detail regarding the Paycheck Protection Program that I summarized in the previous video outlining the key stimulus programs for small businesses. As you may recall, this slide is simply the overview slide of the Paycheck Protection Program that I presented in the previous video. In broad terms, it's a $350 billion program to provide small business loans equal to 250% of the business's average monthly payroll up to a maximum amount of $10 million, which can be used to make payroll, cover overhead, and avoid layoffs for about 2 months. And for small businesses that use the loans in this manner, the loan can be entirely forgiven with no tax consequences. I expect demand for these loans to be considerable, so let's take a look at some of the details. First, when does the program start and end? Technically, a Paycheck Protection loan must be made between February 15th, 2020 and June 30th, 2020. As I'll discuss later, however, all of the loans will be originated by a network of SBA licensed lenders according to rules set forth by the Small Business Administration, or the SBA. The SBA released interim rules on April 2nd, and some banks have begun issuing Paycheck Protection loans. However, many banks remain on the sidelines, hoping for additional clarification. We plan to provide on our Berkeley website a list of lenders that we have identified as accepting applications. In any event, the loan program will end on June 30th of this year. Now, who can be eligible for a Paycheck Protection loan? I've broken the requirements into basically two parts. First is a simple size requirement. For a for-profit firm, you have to either show that you have fewer than 500 employees or that you otherwise meet the SBA size criteria. These size criteria are set forth on the SBA's website, and while they generally impose a 500 employee maximum, there are a few industries where the focus is on revenues rather than size. So if you have more than 500 employees, you'll want to check out these standards to see if you can still apply. Additionally, it's not just for businesses that are formed as a corporation or an LLC, but sole proprietorships and self-employed businesses can also apply. Small nonprofits are also eligible so long as they have no more than 500 employees, as are travel businesses concerns that meet the SBA size requirements and 501c19 veterans organizations that meet the SBA size requirements. In addition to meeting the size requirement, you will also need to show that your business existed on February 15th, 2020. Other than this test, there's no requirement that you have any specific history of operations. But again, these loans are going to be originated by independent lending institutions, so it's possible that some institutions may impose greater operating history requirements than this baseline requirement. Also, you'll need to make the following 4 certifications to a lender, and these are straight from the statute. First, you have to certify that the uncertainty of the current economic conditions makes necessary the loan request to support your ongoing operations of the borrower. Second, you need to confirm that the funds will be used to retain workers and maintain payroll or make mortgage payments, lease payments, and utility payments. The third and fourth requirement get to the point, which is that you can only get one payroll protection loan, that is, unless Congress extends the stimulus program. So you have to certify that you don't have another SBA loan application that's pending for the same purpose and duplicative of the amounts applied for, and that you haven't previously received a Paycheck Protection loan. Now, this last requirement does raise an issue about what happens if you've applied for a SBA disaster loan, and the statute actually anticipates this possibility and provides that if you've received an SBA disaster loan since January 31st, 2020, you can actually fold it into a new Paycheck Protection loan. This gets to the next question of how much can you actually borrow? Formally, you can get 250% of your average monthly payroll costs in the year prior to the loan date. Now, if you haven't operated for all of 2019, the amount is going to be 250% times your average total monthly payroll costs incurred for January and February of this year. And in all cases, the total amount of the loan is going to be capped at $10 million. It's also worth flagging that the actual calculation of average monthly payroll will use a specific definition of payroll costs that includes and excludes various items. For instance, it includes wages and salaries for employees only up to the wages and salaries and annualized pay of $100,000. And it also includes sick leave, healthcare, and other benefits, but it excludes sick and family leave related to COVID-19, which is covered by the refundable tax credits that I discussed in the previous video. Loan forgiveness. Obviously, this is going to be an important question for most borrowers. In principle, up to the entire loan amount can be forgiven with proper planning and record keeping. Now, how much would actually be forgiven in a specific case? Well, that's going to depend on a two-step analysis. In step one, we first determine the maximum forgiveness amount, which is generally going to be the principal amount of the loan that is actually spent on the following costs in the 8-week period after the loan is dispersed: payroll costs, interest on any mortgage obligations incurred for the business, rent, payments on utilities, and for borrowers with tipped employees, additional wages paid to those employees. It's also worth noting that the SBA recently released rules on April 2nd that indicate that no more than 25% of the forgiven amount can consist of non-payroll costs. So if you intend to use a Paycheck Protection loan to pay for substantial non-payroll costs, the forgiveness amount would effectively be equal to the total amount of your payroll costs during the 8 weeks after you receive the loan divided by 75%. Now, it's going to be very important that when you apply for loan forgiveness, that you can document that the loan was made for these purposes. As a result, it would be ideal if you could set up a separate bank account that would receive the loan proceeds and that you would then use to make your payroll costs, your interest on mortgages or rent or other utility payments in order to document that you qualify for loan forgiveness. But that's step one, and it determines the maximum forgiveness amount. However, there is the possibility that this amount could be reduced if you do not maintain your payroll at specific levels. This is the focus of step two. Under step two, the lender will evaluate whether there has been either a reduction in headcount or a reduction in the aggregate wages and salaries that you pay to your employees. Focusing first on the headcount test, the actual forgiveness amount will equal a fraction of the initial forgiveness amount determined by taking the average number of your full-time equivalent employees per month in the 8-week period after you receive the loan and dividing it by one of two options. First, you could divide it by your average number of full-time equivalent employees per month from February 15th, 2019 to June 30th, 2019. Or alternatively, you could use as your denominator the average number of full-time equivalent employees per month from January 1st, 2020 to February 29th, 2020. So, for example, if the average number of employees during the 8 weeks after you take out the loan is the same as the average number of employees in the first 2 months of 2020, the fraction would be 100%. You would be entitled to 100% loan forgiveness, assuming you satisfy the other requirements set forth by the lender, such as the paper and record keeping requirements. However, even if you don't have a loan forgiveness reduction due to a reduction in your total headcount, you can still have a reduction in your loan forgiveness amount if the total amount of your salaries and wages paid to employees during the 8-week period after the loan is dispersed is less than a specified level. Under the Act, the second loan reduction amount is calculated in the following way. You would take the initial loan forgiveness amount and reduce it by an amount that equals, for each employee, the amount by which the employee's total wages and salary during the 8-week period after you receive the loan is not at least 75% of the employee's wages and salary in the most recent full quarter prior to the 8-week loan period. However, for this purpose, you would only look at employees who did not receive in any pay period in 2019 wages or salary at an annualized rate of pay in an amount more than $100,000. So in short, to apply this provision, you would exclude all employees with annualized pay greater than $100,000 and then go for these remaining employees, employee by employee, to see if the remaining employees are paid during the 8-week period after you receive the loan at least 75% of their total pay in the most recent quarter ending before you took out the loan. For any employee who wasn't paid at least 75% of their prior pay, you would see a reduction in the loan forgiveness amount equal to the aggregate amount of the shortfall for all of these employees. To be honest, I'm a bit confused about how this language will apply in specific cases. For instance, what if your employees in the 8-week period are different than your employees in the prior quarter? But hopefully the SBA will be providing some clarity when they produce the regulations in the coming days and weeks for the Paycheck Protection Program. And you'll certainly want to get clarity on your specific case with your lender. Finally, the stimulus package does anticipate that some employers may have already laid off or furloughed employees, and it has a specific provision to encourage these firms to rehire these employees. That is, the CARES Act provides that any reduction in employment or wages that occurs from February 15th, 2020 through April 26th, 2020 will not reduce the forgiveness amount if by June 30th of this year, the borrower has eliminated the reduction in employees or the reduction in wages. What happens if some portion of the loan is not forgiven? Still, the terms of these loans are quite generous. In particular, the SBA rules provide that the interest rate on these loans will be 1%, and the loan term will be 2 years from the date on which the borrower applies for loan forgiveness. There's also no prepayment penalty and no personal guarantee, which is unique for this type of Section 7A loan. All principal and interest is also deferred for 6 months. Finally, where do you apply? It's important to emphasize again that these loans are part of the SBA's Section 7A program, which means that you apply at an SBA licensed lender. You do not apply on the SBA's website as you do with the disaster loans discussed in the previous videos. How do you find an SBA licensed lender? There's actually a function on the SBA's website called Lender Match, but it's not currently functioning. It simply takes you to the Paycheck Protection Loan website. But you can simply Google most active SBA lenders, and you get a link to a page on the SBA's website, which provides you with the most active Section 7A lenders for the last quarter. And it basically looks like the following. So you could go bank by bank to identify which banks are currently offering paycheck protection loans. We're actually doing that currently here at Berkeley Law, and we'll be providing information on these banks shortly on our website. And I'll provide a link to our website in just one moment. I want to emphasize again that a lot remains unknown about how this program will actually be implemented. On April 2nd, the SBA released interim rules to allow lenders to begin immediately processing loans. And the spirit of the rules are such that the SBA expects that lenders will not differ significantly in their application requirements. And the SBA even provided a uniform application, which you can find at this link. But lenders remain free to impose additional criteria. On this note, it's critical to understand that even with the SBA rules, it's likely that individual lenders will have a lot of discretion. In particular, banks will detail the actual requirements that will apply for loan forgiveness, and the loan forgiveness application is actually made to the lender who makes the call. Lenders will also have to determine how to calculate your average monthly payroll. In any event, I can't overstate the importance of finding a lender that provides clear guidance, especially on the loan forgiveness criteria and the need to have a candid and well-documented understanding of how loan forgiveness will apply to your specific situation. My contacts at the SBA have advised me that the best way to stay updated on this program is simply to register for updates on their website, which you can find at the following link. I also mentioned previously that we're going to try to provide updated information on banks that are participating in this paycheck protection loan on our website, which you can find also at this link. That's pretty much the program in a nutshell. It's worth noting again that to keep things simple, this has just been a summary of some of the key provisions, and you'll naturally want to seek legal and tax advice before signing up for a paycheck protection loan. But hopefully this summary is helpful to you as you navigate the various stimulus programs.